Before the court, the defendant filed his motion to establish a specific parenting time schedule. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the petitioner, defendant, father Brody Barron. Mr. Barron appears to be present. In addition, Attorney Leah Rourke is present, representing the plaintiff mother, Leona Gooch, and Moose Gooch appears to be present. Good morning, everyone.
Good morning.
Good morning, Your Honor.
Good morning.
Good morning.
Parties have conferred this morning with Rich Walker for the court, who's provided the court the following recommendation, providing for a specific parenting time for defendant father. Of the minor child parties, father's parenting time shall be every Monday and Tuesday overnight. Mother shall have Wednesday and Thursday overnight. The parties shall alternate Friday through Sunday overnight. The exchanges shall be at 7 p.m. When the minor child turns 5 years old, child is right now a year and a half. When the child turns 5, each party shall have 2 non-consecutive weeks of parenting time with 30 days notice. Presumably that's summertime parenting time. Mother shall pick first in odd years. Father shall pick first in even years. Again, 30 days advance notice to the other party. The front of the court holiday schedule shall also be adopted, unless the parties agree otherwise for specific holidays. That is a recommendation. Ms. Sikorsky, is this recommendation agree with your client this morning?
It is. Thank you, Your Honor.
When will this schedule commence?
We didn't talk about that.
Okay. Just so everyone's on the same page before we leave. So we'll address that in one moment. Ms. Work, is this recommendation agree with your client?
It is, Your Honor.
Wonderful. So Mr. Barron, Ms. Gooch, can the two of you work out when this schedule will start?
Yes, Your Honor. We could probably figure it out today, tomorrow.
Okay. All right. It's wonderful. The court applauds the parties for reaching their own agreement. Mrs. Gorski, do you wish to voir dire Mr. Barron?
No, thank you. It's not necessary. These parties actually co-parent very well.
Wonderful. Ms. Worka, do you wish to voir dire Ms. Gooch?
No, thank you, Your Honor.
Wonderful. All right. The court will adopt the recommendation. Good job, mom and dad. Your child will benefit from the two of you being able to co-parent. And there's still going to be challenges in the future where you may need to be flexible. If something comes up, communication is the key. So please keep that in mind. And the court will adopt the recommendation. The court finds an agreement between the parents to be in the best interest of the minor child. The court will adopt the agreement, and that will conclude this hearing. You can both zoom out. You'll both get a copy of this order from your attorneys.
Thank you, Judge.
Thank you, Ms. Sikorsky, Ms. Worka. That'll conclude this matter.
Judge.
Versus Teresa Gilliland.
For the record, this matter is before the court on the plaintiff's motion for alternate service of a complaint for divorce upon the defendant. This hearing is being conducted via Zoom. President Attorney Billy Jeffers, representing the plaintiff Seamus Gilliland. Mr. Gilliland is present. Good morning.
Morning, Judge.
The defendant is not present, obviously. Whereabouts are unknown. Mr. Jeffers, just curious why typically 99.9% of these cases are all submitted by simply a motion for ex parte order. Is there some reason why we set this for hearing?
Judge, that's a good question. I'm not sure what Mr. Godfrey had in mind. I believe if I had to make a guess, it's because of the numerous and ongoing issues that the parties have had, specifically the defendant with rehab and with the medical bills and Miss Gilliland's outstanding warrant with Monroe County. I believe that Mr. Godfrey was just being very thorough with this.
Okay. There's no harm in it, but there's a minor child involved. Where does the minor child reside? Is that a minor child with mom or dad?
With me, Your Honor.
All right. Okay. So, Mr. Gilliland, your wife Teresa has not made any contact with you recently in terms of giving you some idea where she's at?
No idea, Your Honor.
All right. The parties have conferred with Ms. Patrick. She's indicated that the motion for alternate service be granted. Specifically, Mr. Jeffers is to be service by publication.
Yes, Your Honor.
We don't have too many addresses to do substituted service. So specifically, if the court's going to, the order should specifically provide for service by publication for the court rule.
Yes,
And
Your Honor.
there's expense associated with that, but we don't have any valid address from the postal service. So I don't think substitute service is feasible. Do you have any thoughts?
I believe that publication is the best option, Your Honor. I think it would probably not be beneficial based on the research that the plaintiff and Mr. Godfrey have done trying to serve all these various addresses. I have an order prepared here that does specifically grant publication of the summons that was issued. So I think that's the best way to approach this.
Very well. Ms. Patrick, you can just delete from from the queue that order. So the court wants it to be very specific. So Mr. Jeffers, yes, we'll make a note that you'll be submitting an order for service by publication. And go ahead and get that processed and ready. We'll get this sooner. We get it published. I think it's got to be published 3 consecutive weeks. Is that correct? In the local newspaper?
That's per the court rule, yes, Your Honor.
Okay. All right.
We will have that to you sometime early this afternoon.
All right. Wonderful. All right. That motion's granted. Thank you.
Thank you, Your Honor. Thank you, Ms.
Thank
Patrick.
you, Judge.
Mr. Gilliland will be in touch.
Thanks.
Thank you.
Thank you. Thank you, Ms. Patrick. You can delete that from the court's queue because I'm going to specifically sign the order for service by publication. There are alternate means, but this is clearly a case for publication. All right.
Thank you.
All right. Thank you. For the record, this matter is before the court on the plaintiff's motion for judgment against defendant for failure to pay a debt to Directions Credit Union. This hearing is being conducted via Zoom. Present is Amy Rose Koviak, representing the plaintiff petitioner, Lori Champagne. Ms. Champagne is present. Defendant Wayne Champagne is also present. Good morning, everyone.
Good morning.
Morning.
Morning, sir.
The parties have conferred this morning with Mr. Pratt, who's provided the court the fine recommendation that the defendant Wayne Champagne shall pay to plaintiff Lori Champagne $15,000 that was paid by the plaintiff out of the recent closing on the Monona Drive property. And he shall also be responsible to pay the balance of a loan that's been added as a lien on the Scott Street property of $4,915.53. That's the relief you're requesting, Ms. Koviak. Is that correct?
It is, Your Honor.
All right, Mr. Champagne, your response?
Yeah, I disagree with Mrs. LaPrade. She kind of, one time she said she couldn't see it in the divorce decree, and it was never in the divorce decree. They violated the first court order that she wants to say that judgment was added to there, and it was not.
All right, so you disagree with the recommendation, Mr. Champagne. So the court has a number of questions. First of all, this case is a mess. I mean, it's been piecemeal together.
Well,
where in the judgment of divorce or stipulated orders, Ms. Koviak, is this Directions Credit Union loan addressed? I don't see anywhere.
It is not, Your Honor, because of, as you said, we had quite a struggle to get it
all.
all.
In whose name was this debt? Is it Mr. Champagne's name only?
Mr. Champagne's name only.
Okay, and was there not discovery during the course of this divorce they didn't know about? You and Mr. Champagne did not know about the debt?
Number one, we did not know about the debt until after, if you look at the timeline, there is a stipulated order from May 7th of 2021, where my client was awarded the Monona property and the Scott Street property. And then there was also a final decree of divorce, which was entered.
Yeah, I've looked at the judgment. I've looked at stipulated orders. Where the stipulated order of May 5th specifically awards Monona property to the plaintiff, and she shall refinance any debt thereon. Was this debt to Directions Credit Union was ever secured by a mortgage on any property?
It was put on the property after it was given to her.
Understood. When the loan was taken out by Mr. Champagne, was it ever secured by a mortgage, or was this an unsecured debt?
No.
This was unsecured debt?
Correct.
Okay, and so neither you nor your office or Mr. Chappell or Ms. Champagne knew about this debt until the judgment lien came to surface in 2024. Is that correct?
When the judgment lien came into place, yes.
Right. And this debt was only in Mr. Champagne's name?
That is correct.
And obviously the court understands the time frame. The property, Monroe Drive, was quitclaimed by Mr. Champagne to Ms. Champagne in December of 2022. The judgment lien was recorded 3 months prior thereto in September of 2022. So obviously the judgment lien attached to the Monroe property because it was the name of Mr. Champagne prior to the quitclaim transfer. Is that correct?
That is correct. That's my understanding.
All right. So I guess we need to reopen this divorce case and then determine who's responsible for that $19,000 loan. I mean, is it a marital debt? Is it a debt, business debt of Mr. Champagne? I guess we need to have a trial on that. We need to reopen this divorce case. It's not addressed in judgment. It was an issue that no one knew about.
Well, Your Honor, I would argue that the fact that she was supposed to get the Monroe property free and clear of any debt.
Well, hold on. No, it said she should refinance the debt thereon. Didn't say it was free and clear.
That was debt thereon at the time that it was transferred, that it was given to her. That was subsequently put on to, the debt was put on there after it was,
Okay.
after it was granted to her.
Understood. All right.
But Your Honor,
Mr. Champagne, you had attorneys throughout this divorce action, and your attorneys should have disclosed that. Wasn't there discovery, Ms. Waskowiak, when they're interrogatories where people have disclosed debts?
There was, Your Honor, and I would say, as I said before, because of the piecemeal nature of this, if you will look at, I don't remember what exhibit is, but it goes to all the property that the parties distributed. And I'll tell you what happened on the stipulated order that was signed on March 5th of 2021. They distributed various property with the husband getting a Chevy pickup truck, a Harley, a Suzuki, a rat rod, and those had various items of debt on them. And if you'll notice, we put them as an agreed value of 0 with the idea that Mr. Champagne was going to take the debt that was associated with those items. So it's our argument that even though the debts were not specifically allocated in the judgment entry, they were taken into account when we distributed certain property. So I understand it is not clear as it should be, but I think that was the understanding when we came to those, because obviously I can go back, the Harley did not have a value of 0. It had a value of $27,000 or something, and then there was a $27,000 debt that was associated with it.
Your Honor, if I could say,
Mr. Champagne, what was this debt obtained for? What did you do with the $19,000, the debt? Did you buy a Harley with it?
no, I don't know why they've got, I hate the word meal piece. It sounds so unprofessional. The meal piece.
Mr. Champagne, this is not a trial. I don't have all morning. I've got cases every 15 to 30
Well,
minutes.
let's settle it. Let's settle it when you have time, then. I think we should settle when we have time. That's the second time you've told me that you don't have time for me. And
Mr. Champagne, I'm just answering the question, please. I'm trying to focus your mind. What was this debt obtained for? Did you buy a motorcycle with it? Did you make home improvements with it?
No, Your Honor, it was a marital debt prior to our divorce. It was a line of credit.
Okay. Well, we need some information about that. That was only your name. You say it's a marital debt. Why wasn't it discussed by your attorneys at the time of the divorce? If you claim it's a marital debt, it appears on the surface to be your debt alone.
That's correct. But Mr. Champagne never had a job when we were married. So any lines of credit, any loans, all the properties, those were all in my name, Your Honor. So if you looked at it on the surface, it would be all my debt. But we know during the divorce, and I've learned that if the debt occurs during the marriage, it's a marital debt. So
get back to the question the court asked, Mr. Champagne. What was the loan secured for at the time?
Help paying the payments. When Mr. Champagne left, I was using the line of credit. I had another line of credit at the credit union. Sometimes my checks wasn't enough to pay the bills. I had to take a few hundred out here to pay for, the gas, the utilities, buy things for my girls. There was a $7,000 side-by-side purchase from the Directions Credit Union. That was a gift given to Mr. Champagne's nieces and nephews that we were raising. They were foster children of ours. They destroyed the machine ultimately as junk, but these were definitely lines of credit that Mrs. Champagne was aware about. It was before she filed the divorce, while we had the children. So to try to answer your question, it was used for marital funds to keep my house going, to keep the bills on, and part of it was to keep the children happily and entertained when I was at work.
Well, all right, thank you. But again, most lines of credit usually are secured by a mortgage. It's unusual they have a just open line of credit
I don't
without
know
any
that.
security. But the fact that it was in your name alone, Mr. Champagne, you should have raised that issue during the divorce proceedings to make it really clear that, no, this is not my debt alone. Even though it's in my name, it should be a marital debt, and we need to address it as part of the divorce settlement. So absent
Honor, I
that,
got-
Mr. Champagne, it appears to be your responsibility. And the only reason that it got put on this property is because it was attached to the title. The property was in your name. And then the judgment lien attached was recorded in September. You quit claimed it in December. So that lien was already attached at the time that you quit claimed it. So it should not have been responsibility of Miss Champagne to pay that.
Well, that's not so, because Mrs., when you say you don't have time, and that's what's aggravating me the most.
Mr. Champagne, this is a motion hearing. Do you want a trial date? I mean, this is a motion hearing.
Absolutely.
There's a lot of 15 minutes
Absolutely.
argument. I'm just
I
trying to get
need
to the
you to-
point. Mr. Champagne, I'm just asking for an answer to a question. But
Yes.
go on. I'll let you, do you want to talk I'll give you till 10:30. Keep talking, blabbering on. I'm trying to get to the relevant points, Mr. Champagne, so I can ask the relevant questions to make an intelligent decision. I have time for you, Mr. Champagne. So go ahead.
I said yes. I'd like your time. If you can't give it to me today, I guess the trial is what we need, because I need you to understand what's going on, not what they want you to believe. So when you have time to read the case file and get your facts in order, and we can,
Right.
I would love a trial.
All right, we'll get a trial date. You're gonna represent yourself, Mr. Champagne. Nancy, can you bring up the file, please?
Yes, sir.
Okay, I'm just saying, you need to, and Ms. Kovac, you should subpoena the documents from Corrections Credit Union so we can find out the history of this loan.
Yep.
It appears initially on the surface to be that responsibility of Mr. Champagne because it was in his name alone. He should have raised it to the attention of the Miss Champagne and her attorneys at the time of the divorce settlement. Okay, so all right, how about September 19th?
Yeah, I can make it work.
All right, in-person hearing, September 26, 8:30 a.m.
How long did you set for it?
I'm sorry?
How long did you set for it?
Give Mr. Champagne all day, Mr. Champagne.
Thank
So
you, sir.
don't complain to this court that I'm not giving you time. This is a motion hearing this morning, Mr. Champagne. You'd be well advised to retain an attorney. I'm telling you, based upon the preliminary things that I've read, and I've read your 4-inch thick pleadings, and I've read Mr. Chappell's pleadings. It appears on the surface that it's your obligation. It was in your name alone. It was never addressed in the judgment of divorce.
I thought we were going to handle this.
Other than the fact that the Monroe property, this debt should not have been placed on the Monroe property, but for your failure to pay that debt to Directions Credit Union. It was set for in-person hearing on September 26, 8:30 a.m. The court will require that the parties exchange exhibit witness lists and file trial briefs. How much time do you think you need, Ms. Liskoviak, to receive to exchange exhibit witness lists and trial briefs? A week before?
A week
10
before
days
is fine. A week before is fine.
All right. So the court will order that so exhibit witness lists and trial briefs and to be exchanged and provided a copy to the court on or before September 16th. 10 days before.
Okay.
And Mr. Champagne, your mailing address is still, Mr. Champagne, did you receive Mr. Chappell's motion?
No, I did not.
All right, how'd you know about the hearing today?
Oh, I thought you meant through the mail, Your Honor. Through email, correct, yes. That's what they
All right.
often do, is right before they email it to me, and then but I got notice of the next one so I can get more prepared. So maybe it was a miscommunication, but I've never seen anything in the mail.
All right. All right, so Ms. Wiskoyak, and change your mailing address to Mr. Champagne. It's Monroe.
Okay.
All right, so everything will be mailed to you at that address, Mr. Champagne. Anything further this morning?
No, Your Honor.
I was wondering when my counterclaim is going to be discussed.
And what is your counterclaim?
Well, you said you read it, so I mean, I'm suing them for over $100,000 emotional distress, just physical, mental distress. This never stops. I'm asking for reimbursement of all the attorney fees that I've had to pay to defend myself, over $32,000. I'm asking for
We'll
Mr.
address that, and we'll hear all outstanding issues that have been pled to Mr. Champagne on September 26th at 8:30.
Okay, I just want to make sure we're all on the same page so I can get prepared for that, Your Honor.
Ms. Kovac, you can respond to that, his counterclaim as well.
Yes, will do.
Anything further, Mr. Champagne?
No, thank you, sir. Your Honor.
Okay, all right, that'll conclude this matter. Court will mail out notice.
Thank you.
Versus Denver Goon.
For the record, this matter is before the court for the purpose of reviewing custody parenting time. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the defendant father, Denver Goon. Mr. Goon appears to be present with Ms. Kuhn. In addition, Attorney Amy Woskoviak is present, representing the plaintiff mother, Cassandra Heiserman. Ms. Heiserman is also present. Good morning, everyone.
Morning, Your Honor.
The parties presumably conferred with someone from the front of the court. I don't see any recommendations this morning. Who'd you meet with, Ms. LaPrade or Ms. Patrick?
Ms. LaPrade, Your Honor.
Okay.
Let me check and see where that landed.
The last order entered by this court in April granted extended parenting time to the defendant father, supervised parenting time to the plaintiff mother.
Judge, it shows it's
Now
in
the
your
courts have received
queue.
Yep, I've received the recommendation now, Ms. LaPrade. Thank you.
Thank
The
you.
recommendation of Ms. LaPrade is that parenting time for mother shall be every Wednesday from 5 p.m. to 7:30 p.m. In addition, every other weekend, Friday at 6 p.m. till 6 p.m. presumably on Sunday. I'm sorry. Is that for the weekend, Ms. LaPrade?
Yes, sir. I apologize. Yes, that's supposed to be Friday at 6 to Sunday at 6.
Okay, so parenting time with mother shall be every Wednesday, 5 p.m. to 7:30 p.m. and alternating weekends, Fridays at 6 to Sundays at 6. Parenting time shall occur at the plaintiff mother's home, supervised by Michelle or Wayne Miller. Neither party shall use alcohol prior to or during parenting time. That is the recommendation. Ms. Kuhn, is this recommendation good with your client this morning?
Judge, I'm sorry, I just want to make sure, I want to make sure I heard right. The parenting time is going to continue to occur at the maternal grandmother's home, correct?
Plaintiff mother's home, correct.
Plaintiff
Supervised
mother.
by Michelle or Wayne Miller.
So the issue with plaintiff mother was that she was staying at many different places. We would like the recommendation to state that it shall occur at maternal grandmother's home. We believe she is staying there right now, but we don't want to have an issue if mother goes back to Point Place and stays with the boyfriend. Grandmother is not going to go there. So if possible, we would like the recommendation to state that it would be maternal grandmother's home.
It is.
That's where it has been going on since April. We would also, Your Honor, ask that my client's child support be abated since he has the majority of the time
I'm sorry,
with the
hold on,
child.
I'm sorry, Ms. Woskoviak. I'm sorry, you need to mute yourself because
Oh, I'm
you're
sorry.
coming over Ms. Kuhn. So I'm missing Ms. Kuhn's comments. All right, I'm sorry, Ms. Woskoviak was talking with her client during your statements. Ms. Kuhn, could you, so the plaintiff mother is not the same as the maternal grandmother?
We want to make sure that that's happening because when mother gets upset at grandmother, she goes elsewhere. So we don't want this child going to different homes. So we would like her to continue to have her supervised parenting time at maternal grandmother's home.
Okay, I understand now. All right, Ms. Woskoviak, any objection to that, to clarify this, that the parenting time shall occur at the maternal grandmother's home?
We don't have an objection to that.
Okay, all right, so we can modify that, Ms. LaPrade, to clarify that parenting time shall occur at the maternal grandmother's home, supervised by Michelle or Wayne Miller. And I'm sorry, Ms. Kuhn, the other issue that you wanted to raise?
So the other issue is my client's still paying child support and he has their daughter the majority of the time. My client had extended parenting time since April. He has continued to pay child support. Now we have a schedule set. He shouldn't be paying child support. I'm asking that the court abate his child support. In my motion, I do ask for any other relief. And obviously with the extended parenting time and with their parenting time being supervised and him having the majority of the time, the money would be better spent in his home.
Understood. There is no recommended review dates. Ms. LaPrade, I'm not sure if we should abate child support, but perhaps modified child support based upon this change in parenting time schedule.
Your Honor, it
This
is
was-
probably appropriate to abate. I just need a date by which we would do that.
All right. All right, Ms. Moskoviak, what's your response to the request to abate child support?
We do not have an objection. I still have some issues regarding some other things, but we don't have any issue regarding currently abating child support.
Okay. Okay, what date do you propose, Ms. Kuhn?
Your Honor, he's had her since April, so I would say May 1st.
They didn't.
Ms. Moskoviak?
No, the child was in school in Bedford during that time. Grandmother had, along with mom, had the child during that time. It seems to me that July would be appropriate as a start date, especially since we are consenting.
My clients had their daughter since April 24th of 2024.
Yes, the court notes that an order was entered April 24th, requiring that mother's parenting time be supervised by the maternal grandmother. Mr. Pratt, your recommendation, either June or July?
Your Honor, my recommendation would be June 30th. This was not brought up to me at all in the room. I wasn't aware Mr. Goon was still paying child support, so my recommendation would be to abate as of June 30.
All right. All right, the court will adopt that recommendation. Right, Ms. Koviak, the other
Okay.
issue that you want to address?
So my client knows that she has work to do. However, she was the primary caretaker of this child along with the maternal grandmother. That's the primary place where these children were living, or this child was living, excuse me. And the father had every other weekend and one night a week. So I think it's quite drastic to suggest that the child only have every other weekend and one night a week. My suggestion would be that there be in mother's off week that she have an extra overnight of parenting time. So for example, instead of just Wednesday, when it's not her weekend, she have either a Tuesday, Wednesday, or a Wednesday, Thursday. Additionally, it's my understanding that Mr. Goon's girlfriend, when he's working, is watching the child. So I think in this particular instance, as long as there's supervision, the right of first refusal would be appropriate to make sure that that this child get as much contact with the mother as possible. And then finally, I would suggest that there be set phone calls, that my client be able to have phone calls with the child every day. Currently, Mr. Goon is prohibiting that contact, and it is appropriate that there be an ongoing contact daily.
Right, the court would note that on April 24th, the court did refer the issue of custody and parenting time to the front of the court for formal investigation recommendation. Unfortunately, plaintiff mother did not fully participate. She submitted a questionnaire, answers to the questionnaire, but did not call in for an interview. Did she forget about that, Mr. Kovac? Obviously, that's a concern of the court.
I believe that if I were to look, I believe that, go ahead and answer.
I thought they were supposed to call me, so that was a misunderstanding. Yes, my fault, but I thought they were supposed to call me, not me call.
But the court would like to see some documentation showing that Ms. Heiserman is making progress, stabilize her. She's got to be well in order to properly care for her children. So the court's not opposed to getting a review hearing.
Your Honor, I will
I
say
need
that
some
she is set,
documentation in that regard.
she is set for IOP. In addition to, she's going to AA meetings, doing Smart Start. So she's definitely on the way, and I understand that this court wants to observe that. But at the same token, as long as she's being supervised, I would suggest that having ongoing and consistent contact with the child is important, so that this child, especially, not only is she bonded with her mother, but she has an ongoing relationship with her grandmother. And I did forget one other thing, and that is the other potential supervisor would be Larry Heiserman, which is her father. So that would give us a third person in addition to the persons who have been stated, which is her mother and her stepfather, Wayne Miller. So I understand the concern, but I also think keeping consistency for this child to the extent that we can while she's going through treatment is very significant and important.
Your Honor,
Yes, Ms.
plaintiff
Coon?
mother has had numerous relapses. Unfortunately, this has been a continuing issue for many, many years. She has assaulted Larry when she's been intoxicated. She has been found passed out in her vehicle by the Toledo Fire Department while intoxicated. The parenting time that Ms. LaPrade recommended is more than what my client was comfortable with, given that plaintiff mother has an issue with even just being able to control herself. Her mother, her family will testify as to all of that. There was concern that before she went on SmartLink, that she was drunk the week before. Your Honor, she states that she doesn't drink when she has the children, which means she does drink when she doesn't have them. We are not 100% convinced that she is fully recognizing the danger of this situation. And Ms. LaPrade's recommendation, we respect it. We accept it. We're concerned that it's too much parenting time. In addition, the right of first refusal never works, Judge. It never works. And we are not going to agree to a right of first refusal, because what's going to happen is we're going to be in court more often than not over some argument that you didn't let the child come to my house, and then we're putting this child in the middle. So we are not at all advocates of the right of first refusal. I think it creates more problems than what it's worth. And already these two have difficulty with communication. The communication coming from mother to my client is really, really nasty. My client does his best to take the high road, but if I were to send text messages or put them up on the screen, it doesn't present very well for plaintiff mother. So given the issues that we have, given the concerns, given the fact that mother was intoxicated a week before she started SoberLink, which I can provide testimony, we're asking the court to keep the recommendation as is, and let's see how she does. We've been down this road. In 2021, she attended AA, went to counseling. In 2022, she's passed out in her car. In December of 2023, she's assaulting a family member because she's drunk and moving out. And then we're all over the place living in different homes because we're upset with maternal grandmother. There's too much dysfunction. And as of now, Your Honor, we'd like mother to focus on getting herself better and focusing on treatment. We're asking the court to adopt the recommendation of Ms. LaPrade with regard to the parenting time and not expand it.
Right, what about this third party to be a supervisor, Ms. Kuhn?
We were fine with both Michelle and Larry, correct?
Wayne.
Wayne, I'm sorry, Wayne lives in that home as well?
Yes, but not Larry.
Okay, yes, we are comfortable with Wayne and we are comfortable with Michelle. They are husband and wife.
Right,
live
Ms.
together.
Moscoviak suggested another party.
Larry.
We are not
Larry.
comfortable with Larry.
No, he's a drinker.
He is an alcoholic.
All right. All right, is Ms. Heisman currently on probation, Ms. Moscoviak?
Is she on probation?
Yes.
No.
Okay, why is there a requirement of a SoberLink?
There isn't. She's voluntarily doing that.
I see. Okay, all right, okay. All right, well, at this point in time, the court's going to adopt this recommendation, but I'm going to set a review date. The court wants to see some documentation that Ms. Heisman is addressing her situation as she's actively engaged in outpatient. As the court recalls, there are issues more than just substance abuse. There are also some mental health issues. The court wants to see that those issues are being addressed properly. We want to make sure that she takes care of herself so she can take care of her son Carson. So the court set a review date. What do you want? Maybe 45 days?
Your Honor, can
Yes.
can you address the issue of the phone calls?
Well, yeah, FaceTime, and that's reasonable requests. What about FaceTime between mother and son during the week?
I know.
That's fine, Your Honor.
Okay. What do you propose in terms of what days? And perhaps in the evening after dinner?
Do like Tuesday and Thursday?
I'm good with that, yeah.
Can we do Tuesday and Thursday, Your Honor? FaceTime, what time works?
Maybe 7 p.m.?
Yeah,
What time? Bedtime?
yeah,
What time?
7, 8 o'clock.
7 or 8?
About 7 o'clock, Tuesdays and Thursdays?
Are you back from work? Is 7 okay?
Okay.
Okay, yes, Tuesday, Thursdays at 7.
Every Tuesday and Thursday, or Tuesdays and Thursdays in a week in
okay.
which she does not have the weekends?
Correct. The Tuesdays and Thursdays that she doesn't have her weekend. Yes.
Again, obviously, as much contact between mother and child is preferred. Ms. LaPrade, your thoughts?
Your Honor, I don't see why we couldn't do the Tuesday and Thursday every week because mom, as per her statement, was more involved with the child's life. I don't see that being an issue.
All right. So the court will add to the recommendation. Again, just clarify the mom's parent time should be alternating the weekends, Friday at 6 till Sunday at 6. Supervised in the home of the maternal grandmother, supervised by Michelle or Wayne Miller only. In addition, mother shall have parent time every Wednesday, 5 to 7:30 p.m. She'll have FaceTime with the minor child every Tuesday and Thursday at 7 p.m. No alcohol consumption in the presence prior to or during the parenting time. And the final court will set this matter for review. What do you suggest, Ms. Wackowiak, in terms of time frame for Ms. Heisman to secure some reports to share with the front of the court and to Ms. Kuhn? I'm suggesting 30 to 45 days.
Yeah, 45 days.
30 to 45.
Yes, either one, whenever you can get us in.
Okay. 10:15 at 8:30 or 10:16? I'm sorry. About September 24th or the 25th, Tuesday or that Wednesday?
24th works, Your Honor. Wednesday morning works also.
The 25th would be better for us.
Okay.
What time?
25th, I got 8:30 or 9.
Doesn't matter.
About 8:30, court for 8:30. Ms. Kuhn, would that work with September 25th at 8:30?
Can we do that? That works, Your Honor.
All right, so Mr. Pratt, if you just put in the court review, mom's parenting time, September 25, 8:30 a.m.
Your
Yes,
Honor,
sir.
real quick, did you, I didn't hear, does it state that child support is abated as of June 30th, 2024?
Oh, I'm sorry. Yes, we will add that too, that child support, the defendant's child support is abated September 30th, 2024.
Thank you.
Yes, sir. That is in the rec and I will get that uploaded.
Thank you, Ms. LaPrade. Anything further this morning, Ms. Wackowiak or Ms. Kuhn?
No.
Your Honor.
All right, do you want to voir dire your respective clients? Is it necessary this morning?
No.
Okay. All right, thank you, and we'll see you in September 25 then. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you.
Parties have conferred this morning with Ms. Brower from the front of the court, who has provided the court with the following recommendation. Mother's parenting time shall be on a 2-week rotation. Week 1, mother shall have Monday from school to Wednesday to school, and Friday from school to Monday to school. Week 2, mother shall have Wednesday from school to Friday to school. If there's no school, the change time shall be 4 p.m. The schedule commences when plaintiff has possession of a Smart Start device and also will eliminate the supervision requirement for parenting time. This weekend is coming up as Father's Weekend for parenting time. Parties shall agree upon holidays. If absent agreement, the front of the court holiday schedule shall be adopted. The minor child, Carson, shall be enrolled in therapy. The parties shall agree upon a neutral therapist. The parties shall exchange insurance cards for the minor child. There should be no disparaging remarks by either parent about the other parent or allow any third parties to make any disparaging remarks in the presence of the child. There should be no discussion of this case in the presence of the child. The defendant withdraws his motion to change the minor child school district. Party shall continue with Smart Start and shall test at 8 a.m. I'm sorry, the plaintiff shall continue with Smart Start and get tested at 8 a.m., 2 p.m., and 8 p.m. daily. Defendant and Attorney Kuhn shall be added to the email results from Smart Start. Plaintiff shall continue with Vivitrol shots and provide proof to the defendant and Ms. Kuhn. Finally, the parties will mediate with Ms. Brower on November 14th at 8:30 a.m. That is a recommendation. Is Ms. Heiserman still engaged in aftercare, Mr. Chappell?
She's completed her IOP program. Is there any, do you have regular checkups with them in any regard or?
I still just do AA meetings.
Okay.
Okay. Other than AA attendance and who monitors the Vivitrol? Who administers that? A physician?
Is he a regular physician?
It's in Monroe. It's ministries, something.
Catholic Ministries?
I believe so, yeah.
Okay, yep. Her next shot, Your Honor, just for the court's information, is on Monday. So she's already had her first shot. It's a monthly protocol, so her next one is on Monday.
So it's just a monthly
injection,
correct?
Yes, yep.
All right, and because the court's question is who monitored that, but this recommendation provides that Ms. Heisman will provide verification of her injections monthly to Ms. Kuhn and Mr. Goon, correct?
Yes, yep.
All right. All right, there seems to be some order in place. All right, to Ms. Kuhn or Mr. Chappell, do you wish to voir dire your respective clients regarding this recommendation this morning?
Your Honor, from my perspective, I think we've reviewed it in detail with the friend of the court. I believe that she fully understands the agreement. The recommendation is in agreement with it, correct?
Yes.
Okay, yep.
Your Honor,
Ms. Kuhn?
yes, as Mr. Chappell said, we did review the order with Ms. Brower, and I believe that my client understands everything as well and is in agreement, correct?
Yeah.
So I do not need to voir dire, but thank you.
Thank you.
Very well. Thank you, Ms. Brower, for your assistance. Court applauds the parties for reaching their own agreement with the assistance of capable counsel. The court will currently adopt the agreement, which will come in order of the court.
All right. Thank you, Your Honor.
The court will be available on November 14th if, in fact, you want to zoom in and put anything on the record, okay?
Sounds great.
Your Honor, do you want us then just to appear for pretrial, or what would be your wish?
Excuse me, Judge, you are jurisdiction on that day.
Okay.
This is in the morning.
You're out the whole day.
Okay. That must be the ICO Family Law Conference, perhaps? Ms. Kuhn, sometimes I know you attend those. It could be the ICO conference. Okay. So yeah, the court will be in, I think it's in Novi. The court attempts to attend the annual ICO Family Law Conference. So the court will be available November 14th.
Yeah.
Judge White is always willing to entertain any agreement on the record if, in fact, the parties want to put something on the record. If not, you can simply reduce it to writing if there's an agreement to modify parenting time. So, in any event, the court will adopt the recommendation. Now we'll conclude this hearing. Everyone can zoom out. Have a good rest of the day, everyone.
Thank you, Your Honor.
Judge.
You're welcome. Thank you, Ms. Brower. Okay.
You're welcome, Judge.
Case versus Justin Solemson.
Record, Mr. Thompson is appearing via Zoom from the Monroe County Jail this morning. Also present is Monroe County Front of the Court Attorney, Rebecca Hicks. Good morning, Ms. Hicks.
Morning, Your Honor.
Can you provide the court some background information regarding Mr. Solemson and his case, please?
Yes, Your Honor. For the record, this case has a current monthly support obligation of $231 per month.
The last payment was received on October 30th of 2023. There's a current balance of $25,663.90. There is a previous finding of contempt. It's from June 24th of 2016. That was a first finding and the sentence has been served.
And I'm sorry, the arrears are 25,000?
Yes, Your Honor.
Wow. I'm surprised that Mr. Thompson has not been picked up by the Attorney General on a felony non-support charge. All right, so you're asking the court to proceed with contempt finding second offense, punishable up to 90 days, is that correct?
That is correct, Your Honor.
All right, Mr. Thompson, do you understand you're being charged with civil contempt of court for failure to pay child support, second offense? It's punishable by up to 90 days in jail. Because of the possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, court will appoint an attorney to represent you at public expense. You understand that?
Yes, sir.
All right. What's your current mailing address? Are you currently employed?
Yes.
With whom?
Ryan's Roofing Repair?
Ryan's Roofing?
Yes.
When did you last work?
Last week.
When did you last get paid?
Last week.
Okay, how much did you get paid?
It's daily, so you want like for the week or what do you work?
Do you get paid cash for each job?
Yes.
Okay, no, so well, how much money did you receive in cash last week for the last job?
Roughly like $600.
Okay. But that's a sporadic based upon the jobs you have?
I'm sorry, what?
Do you get paid $600 every week, or is that sporadic based upon the jobs?
Sporadic.
All right. Do you own any property of any value?
No, sir.
Do you, has the $600 been spent?
Yes.
All right. All right, the court will grant your request recorded for an attorney. We have another matter tomorrow. Is that correct, Ms. Hicks?
Yes, Your Honor, we do.
All right. We're going to put this, we're going to schedule us for hearing at 9:15 a.m. Grant request recorded for an attorney. It will be via Zoom, from Monroe County Jail. Your attorney will contact you and consult with you prior to this hearing tomorrow morning, 11:15, Mr. Thompson. The court's going to require that you post a cash bond in the amount of $2,500. So this is where we reach out to family and friends, Mr. Thompson. So when you appear tomorrow in court, you can advise the court how much you can come up with, because otherwise you're going to be serving perhaps the rest of the summer in jail. So if you can come up with a couple $1,000s, we can talk about a short sentence, get you back out there and get you back to work so you can take care of this. And one of the things you need to do is file a motion to reduce your support. Right now it's clicking along at $231 a month for something. You got to get off. You're sitting on your hands. Be proactive. The front of the court's willing to help you. The court's willing to help you.
Yes, sir.
So the first thing you do to get out of jail is come over to get a packet. You can fill out the motion yourself. The motion to reduce support. If you don't have regular steady income, can't afford the $231 a month, file a motion to reduce it. Be proactive. Because very soon, if you don't get on top of this, for the state attorney general is going to charge you with a felony criminal offense known as felony non-support, for which you can go to prison. I mean, and you're got to be on the radar with these kind of urges, $25,000. So at this point in time, we'll set this for a contempt hearing tomorrow. Attorney will be appointed to represent you, 11:15 tomorrow. In the meantime, if you want to be released, you got to post a bond amount of $2,500 cash only. Any questions, sir?
I was wondering if my the baby mama was to sign off on that. Would that help at all?
If the urges are due to her and not the state of Michigan, yes, obviously, reach out to her. If she's willing to waive, she can come in front of the court and sign an affidavit that she's waiving support due to her. But again, some of it may be she can't waive any arrearages due to the state of Michigan if the taxpayers were supporting your children. So yeah, reach out to her, reach out to other family and friends.
All right, thank you, sir.
Hey, Ms. Hicks, anything further?
Nothing further, Your Honor. I'm preparing that order and I'll upload it shortly.
All right, you can step out, Mr. Thompson. The record, Mr. Thompson is appearing via Zoom from the Monroe County Jail, having been arraigned on potential contempt proceedings earlier this week. It was granted a court-appointed attorney who's here this morning, Mr. Timothy Leiter. Good morning, Mr. Leiter.
Good morning, Your Honor.
In addition, also present for the Zoom hearing is Monroe County in front of the court, Patrice Patrick.
Morning, Your Honor.
I was informed that Mr. Thompson previously served a full 45 days for a prior contempt. In front of the court was asking that he be found in contempt second offense, punishment up to 90 days. The matter was adjourned to today's date so that Mr. Thompson could consult an attorney. Mr. Leiter, have you had a chance to talk with Mr. Thompson this morning?
Your Honor, yes, I have. I had a chance to talk to Ms. Patrick first, and then I conveyed the potential offer to Mr. Solomonson. He indicates that he wishes to take advantage of Ms. Patrick's offer. Ms. Patrick, if you could put that on the record, I'd appreciate it.
Okay, Your Honor, the front of the court is in fact requesting a second finding of contempt, which would carry 90 days. However, we're asking for 45 days immediate, credit for 2, or he could be released upon payment of the bond of $2,500.
Is Mr. Thompson being held in jail on any other charge right now, Mr. Leiter?
No, Your Honor, just this one.
Okay. All right, to Mr. Thompson, are you satisfied you received the right to legal counsel by conferring with Attorney Leiter?
Yes, sir.
Is it true that you wish to admit to contempt of court this morning, punishable up to 90 days in jail? The front of the court's recommending 45 days immediate.
Yes, sir.
Do you understand if you admit to contempt, there will be no hearing this morning other than your testimony?
Yes, sir.
All right, Mr. Thompson, you can raise your right hand to be sworn, please. Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth? Who? Case? CISE? Mr. Thompson, do you admit and acknowledge that you are obligated to pay child support for the support and maintenance of children born to you and Miss Case?
Yes, sir.
Do you admit and acknowledge you have arrearages in excess of $25,000?
Yes, sir.
Have you had any income in the last 6 months?
Yes.
And you admit and acknowledge you've not paid any of that to income toward your child support obligation. Is that correct?
Correct.
Mr. Leiter, do you have any questions of Mr. Thompson?
Your Honor, I don't have any questions, but since this is a second contempt, I don't know if we need to place on the record a prior first.
Thank you, Mr. Leiter. That may be appropriate. Mr. Thompson, do you admit and acknowledge that you were previously found in contempt of court for failure to pay child support, and you ultimately served 45 days over a period of time?
Yes, sir.
Right. Do you have any questions, Mr. Leiter, of your client?
No, Your Honor, we thank the court.
Ms. Patrick, do you have any questions of Mr. Thompson?
I do not, Your Honor. I do request an adjournment date from the court, though, of September 24th at 10 a.m.
Mr. Thompson, when were you last employed?
Last week.
Okay. Refresh the court's memory. You have the court point sheet. Okay.
Your Honor, I believe he said that he worked for Ryan's Roofing Repair.
Okay, thank you. We still have that job, Mr. Thompson?
Yes, sir.
Okay. If that's seasonal, you need to, the front of the court is a 4-page list of employers that are screening for employees. So if it's seasonal, and it's not regular and steady, you need to look at alternatives, Mr. Thompson. This matter is not going to go away. And if you don't really make some significant progress toward reducing these arrearages, the Attorney General is going to charge you with a felony criminal charge called felony non-support, for which you go to prison. So be proactive, follow motion to reduce your support if you don't have the income.
Yes, sir.
Now you have some assets, correct? Did you say you had a jet ski and a boat?
No, sir.
Okay, I'm referring to someone else. Next time, can you pick up those credit card sheets? So you have information on there that's not relevant. Okay. Do you own any property of any value that you can sell?
Just the house that the kids live in.
Okay.
Which I have a question actually for you, if you don't mind.
Go ahead.
Can my baby mama actually come in and sign off on that $2,500?
Only if the arrears are due to her. If they're due to the
Okay.
state of Michigan, she can't waive arrears due to the state taxpayers. But if it's due to her, she can waive any arrears due to her. Ms. Patrick,
Okay,
can
thank
you
you,
tell
sir.
offhand how much arrears are due to plaintiff mother?
The majority of it is due to the plaintiff mother, Your Honor. There is some money. There's approximately $2,000 that are owed to the state of Michigan. And then we're looking at another $1,000, $1,500 worth of fees that are owed to the county and to the state. So the majority of the money is owed to the custodial parent.
Right. Have you reached out to Ms. Case?
Yes, I thought she was going to be here today, but apparently she's not made it in yet.
So, Mr. Thompson, the court wants nothing more than for you to get back to work so you can start paying this child support. How much can you post in terms of bond? It's recommended $2,500. The court's willing to consider something less than that. Can you post $1,500?
I could try.
Well, you reach out to Ryan, your employer, and some family
Right.
and friends. It's going to apply toward your arrearages.
Yes, sir.
All right, Mr. Thompson, anything you want to say before the court imposes sentence?
So that'd be $1,500 if I can. You drop that
I'm
down.
just asking. I'm trying to. It's been recommended
Okay.
2,500. And I'm asking, can you post something less than that?
Hopefully.
All right. Anything you want to say, sir, before the court imposes sentence?
No, sir.
Mr. Lader, anything further?
No, sir. We thank the court.
All right, Mr. Thompson, I wanted you to get back to work. So the court's going to impose a sentence as follows, having, first of all, based upon your testimony that's been presented this morning, the court finds that a support order exists. There are arrears in excess of $25,000. You acknowledge having income in the last 6 months and not paid any of that toward your child support. Your lack of due diligence is the basis for contempt. The court will only find you guilty of contempt, second offense. You are ordered to serve 90 days in Monroe County Jail as follows: 30 days immediate. I'm going to post something less, so I recommend 30 days immediate. Give them credit for the 2 days you have served. That's 28 days in jail. But you can be released immediately upon posting the bond amount of $1,500 cash only. So if you can post the $1,500, apply toward your marriages, and you'll be released. Otherwise, you can serve the next 28 days in jail. And finally, order to appear before the front of the court for review September 24th, 2024 at 10 a.m. A copy of the order sent forth this date and these terms will be faxed over to the jail. You also get a copy mailed to your address. Do you have any questions, Mr. Thompson?
No, sir.
We'll make some phone calls. If you can post the
Yes,
bond,
sir.
plus if in this case we'll waive arrearages, you can be in a much better position. But you need to start paying your current support, the $231 a month.
Correct.
All right, anything further, Mr. Lader, Ms. Patrick?
No, Your
No,
Honor.
nothing further, Your Honor.
All right, thank you, Mr. Lader, for your assistance. Mr. Thompson, you can step out.
Thank you.
Nalabai versus Joshua Grissom.
Sir, can you please state your name for the record?
It's Joshua Grissom.
Thank you. For the record, Mr. Grisham is appearing via Zoom this morning at the request of the front of the court. Also present this morning is Monroe County front of the court attorney, Rebecca Hicks. Mr. Grisham, when you're brought before this court, obviously that means that you are significantly delinquent with respect to your child support obligation. The front of the court's asking the court to move you closer to spend some time in jail. Ms. Hicks, can you provide the court with some information regarding Mr. Grisham and his case, please?
Certainly, Your
Okay.
Honor. In this matter, this case has a current monthly support obligation of $522 per month. The current arrears balance is $5,319.09. He was last on my show cause docket on June 18th of 2024, which it was adjourned to today. He was to apply to 10 jobs per week and provide proof to the friend of the court or start paying his support. At his hearing this morning, he met with Ms. Brower. He indicated that he's been working for approximately 2 weeks. He made about $600. He hasn't paid anything towards his child support obligation. He didn't contact his friend of the court caseworker. He also claims that he's a 1099 employee, but support is coming out of his paycheck, which is not possible as we don't have his employer in our system. We've not sent any sort of income withholding notice. So at this time, the friend of the court is requesting a finding of contempt.
What was the last pay?
April of this year, Your Honor.
All right, Mr. Grissom, do you understand you're being charged with civil contempt of court for failure to pay child support? Upon conviction, you could be ordered to serve up to 45 days in jail. Because of the possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, court will appoint an attorney to represent your public expense. Do you understand that?
Yes, sir.
Are you asking for a court-appointed attorney? I'm going to grant one to you, Mr. Grissom, because there's a really good chance you're going to go to jail.
Oh, yes.
So why don't you give me a cell number the attorney can reach you at? Right. Okay. With whom are you currently employed?
I'm employed. I'm employed through this company called H&N.
I'm sorry. Repeat that. Called ATN.
H&N.
H&N.
H&N Logistics.
And what do you do for H&N Logistics?
I just pick up loads and drop them off.
So you drive a truck?
Yes, I drive a box truck for them.
How long have you worked for H&N Logistics?
This is my second week right now. Going on my second week yet.
Is it full-time or part-time?
Full-time.
Okay, what's your average take-home per week?
About 700 a week.
How many paid have you? When were you last paid?
I got my first check was on Monday
of this week.
Yes, sir.
Okay, don't spend that $700. You need to bring that to court with you this week. All right, so the court's going to appoint an attorney to represent you on this matter, Mr. Grissom. The attorney will contact you with your cell number. The court's going to order you personally appear. I want you to get together $1,000 cash to avoid some immediate jail, Mr. Grisham. Can you do that by tomorrow, or do you need a couple days later on in the week?
Can I give it to you? Can I give it to you Monday?
All right, the court's going to order you appear then. Is that a day agree with you, Ms. Hicks, on next Monday, the 29th of July?
Yes, that works, Your Honor.
All right, right, Mr. Grissom, you are to personally appear in this court on Monday, July 29th, 11:15 a.m.
Okay.
And the court would suggest bring $1,000 cash to pay toward your arrearages, pay that in front of the court, and then come up here to the court. If so, the court's inclined to adjourn the matter. I'm sorry, the court would not impose immediate jail. If you can't come $1,000, then bring your toothbrush.
I was wondering, can we do 750? If not, or I got to be 1,000.
$1,000, Mr. Grissom. You've got arrearages in excess of $5,000. So reach out to family and friends. You don't want to spend part of your summer in jail. So again, that's Monday, July 29th, 11:15 a.m. Personally, Judge Bronx Court, the 4th floor of the Monroe County Courthouse. The attorney will contact you and talk with you between now and then. You have any questions?
Yeah, when I go down there on Monday, can I with that I submit like a review on my child support, can I?
Well, what you should do is if you're not making the kind of money, then yeah, file a motion to reduce your support. Talk to your caseworker, be proactive.
Okay, I got you, sir. All right, I'll do all that Monday, and then I had $1,000 to you on Monday.
All right, we'll reach out to family and friends to come up with that. Court just wants you back on track. Gotta be proactive, Mr. Grissom. All right, we'll see you on Monday then, 11:15 a.m. personally.
Okay.
Anything further, Ms. Hicks?
You said 11:15?
11:15, correct. We
11:15.
want to get you over
All
to
right.
jail. We want to get you over there before lunch if you can't come up with $1,000.
Okay.
Nothing further,
Anything
Your
further?
Honor. I'll prepare that order and upload it to your queue.
All right, Mr. Grissom, you're all set. You can zoom out. We'll see you on Monday at 11:15. For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. The president is Attorney Leah Worker, representing the plaintiff mother, Aisha Parker. Ms. Parker is present. In addition, defendant father. Sir, you're Andrew Chapman, is that correct?
Yes, Your Honor.
Right. Good afternoon, Mr. Chapman. The parties have conferred this afternoon with Ms. Patrick from the front of the court, who has provided the court with the following recommendation. A defendant, father shall have therapeutic parenting time with both minor children at family counseling shelter services. The defendant father will contact Minnie Mitten agency regarding medical coverage for therapy for the minor child Alexander in the next 48 hours. Plaintiff mother is granted written and verbal access to the explanation of benefits in relation to defendant father's insurance coverage of the minor children. The EOBs or explanation of benefits regarding the minor children will be mailed to the plaintiff mother's current address. The father will complete any and all forms that give his mother access to health care insurance coverage information regarding the minor children. And the prior order of CPP therapy will remain in effect for the defendant father and both minor children. That is a recommendation. Ms. Work, is this recommendation good with your client this afternoon?
It is, Your Honor.
Mr. Chapman, do you understand the recommendation?
Yes, Your Honor.
Do you have any objection to the court adopting this recommendation?
None, Your Honor.
Okay, Ms. Patrick, do you have any idea of the current waiting list, timeframe for waiting list for therapeutic parenting time?
I believe it is like 6 to 8 weeks, Your Honor, but the parties are already on the list. Mom stated that she had spoke to them and they are currently on the list, so their wait time should be a little less because they're already on the list.
Okay, all right, and Mr. Chapman, you already had an intake with the Family Counseling Shelter Services, is that correct?
Yes, Your Honor.
Good. All right, the only question the court would have is, should we set this matter for review? So that we can, obviously we want to move forward. If the therapeutic parenting time works well, then we can have some normalized parenting time between dad and the children. Ms. Work, any objection to is the court's got a review date, perhaps in 45 to 60 days?
Your Honor, we do have an objection to the review date because we have been setting this for review continually. Mr. Chapman has been saying for the better part of a year that he would be engaging in CPP therapy. He's not done that. The court's prior order that the supervised parenting time with Athena continue from the last review until now. He did not contact or follow up with Family Counseling and Shelter Services to schedule that supervised parenting time while they were on the wait list for the therapeutic. My client, we've had multiple review hearings wherein Mr. Chapman says that he's going to follow through or do things that he's not done. My client's continuing to incur costs and attorney's fees for these review hearings where he's not followed through. So we're not requesting a review date. My client is hopeful that Mr. Chapman will follow through with the CPP therapy. She thinks it's very important. When he does that, while the CPP therapy is specifically for Alexander, Athena is present for that therapy as well. So it's an opportunity for him to visit with and engage with both of the children. And that would be in addition to the therapeutic parenting time at Family Counseling and Shelter Services. And so we would ask that we not have a review hearing set, and that if Mr. Chapman feels that something needs to change beyond this order, that he motion the court, and my client would do the same.
Bro, it certainly does take up a lot of courts, the time of this court having to schedule and reviews every other month. The child parent psychotherapy, that is through University of Michigan, is that correct?
Yes, Your Honor.
Okay, I'm sorry, has that commenced or not yet?
So the kids have been in CPP therapy for quite some time. My client is engaging in that therapy with them. Mr. Chapman has not followed through with contacting to be involved in that process.
All right, and the recommendation is that that therapy continue with both for the benefit of the defendant father and the children. All right, Mr. Chapman. Obviously, you need to move on these matters, and I guess after you've made some progress and things go well, then you can petition the court for normalized parenting time. Do you understand that?
Yes, Your Honor.
Okay, so at this point, we're not going to schedule a review date, so the onus is on you. Hopefully, you'll come back in 60 days and say, I've done this and that. You got documentation, and you can get a form petition from the front of the court and file a petition and get it before the court to modify parenting time. So the onus would be on you because there'd be no review set at this time. Do you understand that?
Yes, Your Honor.
Do you have any questions of the court?
No, Your Honor, I don't.
Ms. Werka, do you wish to provide your client at all regarding this recommendation? Obviously, she did participate in the discussions with Ms. Patrick.
She did, Your Honor, and I would just briefly, please.
All right, please, you can proceed.
Okay. Ms. Parker, can you please state your name for the record?
My name is Aisha Parker.
And you heard the recommendation that Judge Braunlich read into the record?
I did.
Okay, and you agree with that recommendation?
I do agree.
And do you believe it's in the best interest of both of your minor children?
Yes, I do.
Okay, and you're asking the court to adopt that as the order?
Yes, I am.
And are you satisfied with my representation?
Yes, I am.
Thank you, Your Honor. I have nothing further.
All right, thank you, Ms. Werka. So the court would urge you, Mr. Chapman, to follow through with some of these things. Contact University of Michigan, get a session scheduled between you and the two children. They need an active dad in their life. They need you. So please step up and do what you need to do to reestablish that relationship, okay?
Yes, Your Honor.
All right, the court will adopt the recommendation. Copy will be mailed out. Now we'll conclude this hearing. Thank you, Ms. Patrick.
Thank you, Your Honor.
Okay, everyone can zoom out. Have a good rest of the afternoon. For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Alexis Stang, formerly known as Spencer. With her is the plaintiff father, Jacob Hugendorn. In addition, Attorney James Adria is present, representing defendant mother Chelsea Sadkoviak. Mr. Adria, is your client, is she here this afternoon?
I can't hear you, Your Honor.
Is your client, the defendant mother, present this afternoon?
No, she was not.
Okay. Do you need to remind her of the hearing, or you want to
No,
proceed without
she's
her?
aware of the hearing. She had an operation the other day, and she is unable to travel, and she's on a heavily sedated medication.
Okay. There's no need for travel. It's a Zoom hearing. People can appear by their phone in their bed. Any event, you and Ms. Stang have conferred with Ms. LaPrade, who has made a recommendation that the minor child should be enrolled in mother's school district within the next 7 days. Actually, that was ordered back on June 4th. So the prior order did not specify a time frame. So again, obviously, defendant mother needs to enroll the child, and if she's not doing so, I guess the father can enroll the child in his school district. Is that what we need to do?
Yes, Your Honor.
The child is enrolled in school, Your Honor.
No, she is not, Your Honor.
Okay.
So do you have any objection to the court entering this order that the defendant mother enroll the child in her school district within the next 7 days? Mr. Adria, any objection to the court adopting this recommendation?
That's fine, Your Honor. Child's already enrolled. It's fine.
All right. And just for the court's edification, what school district are we talking about?
Toledo Public.
All right. Any objection to that, Ms. Stang?
Yes, I was just gonna say, my client did call yesterday to Toledo Public Schools, specifically Beverly Elementary, where the mom's school district is, that was previously ordered at the last hearing. And they did confirm that the child is not enrolled there. She is not enrolled at Toledo Public School District. And we just are concerned that if the mother does not enroll her soon, then she's not going to be able to have a space. From our understanding, mom, doesn't actually own or even rent or lease the house that she's living in right now. So we're not sure if it's going to become an issue, but in the event that it does, that's why we were requesting that the father be able to enroll the minor child in his school district so that this child can go to school and not be behind.
The child is 4 years old, will be entering kindergarten, is that correct?
Yes, Your Honor.
All right, that's not obviously, it's important, but not critical age. This is Beverly Elementary within the Toledo Public School District.
Yes, that is mother's school district that was previously ordered.
Right, but they did not specify the school. They simply said mother school district, and we should perhaps
Correct.
clarify what school district we're talking about. Mr. Adre, any objection to the court specifying that it's Beverly Elementary and the Toledo Public School District?
I think that the order says mom's school district.
Okay, well, the court would like to identify. Are we talking about
Toledo
Fostoria?
Public
We're
is
talking about
mom's.
Toledo. We're talking about mommy. Let's specify
Toledo.
school district.
Toledo Public.
Okay, there's probably what, maybe half dozen elementary schools. Do we know what elementary school?
There's a half dozen elementary schools within a mile of
Understood.
this elementary school, Your Honor. There are a lot of different schools.
So we're not identifying an elementary school. We're simply identifying Toledo Public Schools. Is that what you're suggesting?
I'm suggesting that.
All right. Any objection, Ms. Dang?
No objection, and just to clarify, it is Beverly Elementary, the specific school.
Well, we don't know if that's the school district the mom lives in, the close elementary. And again, perhaps, Mr. Pratt, we can indicate parentheses Toledo Public Schools, and that mother shall inform dad within the next 10 days of what elementary school she has enrolled the child. So dad can then call that particular elementary school to verify it. I don't know if there's a general phone number for Toledo Public Schools that can identify students that were enrolled in the half dozen elementary schools within their districts. I don't know that, but we'll just identify Toledo Public Schools, and that mother shall notify father within 10 days, the next 10 days of the particular elementary school.
That's fine.
Within Toledo Public Schools. Would that work, Ms. Stang?
Yes.
All right, and the parenting time for dad will continue as previously ordered. Is that correct?
Yes.
All right, is there anything, we'll simply note that the defendant failed to appear. Anything further than this afternoon, Ms. Stang or Mr. Adre?
Nothing, Your Honor.
Nothing further. Thank you.
All right, that will conclude this matter. We'll just clarify, Ms. Pratt, if you could kindly, that Toledo Public Schools and the mother shall notify dad of the particular elementary school within 10 days, please.
Yes,
Thank
sir.
you.
All right, they can zoom out. Have a good rest of the day.
Thank you.